you want to protect yourself and your business because this is hopefully, one of your clients, and you don't want to expose the rest of your business to something that you really didn't have a part to. You were just providing bookkeeping services.
You're listening to The Successful Bookkeeper with your host, Michael Palmer. Listen each week as inspiring guests share their secrets of success to help you increase your confidence, work smarter, and build a business you love. This episode of The Successful Bookkeeper is brought to you by PureBookkeeping.com, the proven system to grow your bookkeeping business.
Welcome back to the Successful Bookkeeper Podcast. I am your host, Michael Palmer, and today's show is going to be a fantastic one. Our guest is a corporate lawyer and partner of the law firm Gibbs Giddon in California. Jeffrey Love, welcome to the show.
Thanks so much for having me. I'm excited to be here.
It's great to have you, and I'm looking forward to this conversation. It's a timely conversation around understanding the law in a way. And before we get into all of that, Jeffrey, please tell us about your career journey leading up to this point.
Sure. So I always wanted to be kind of behind the scenes in business. Had the entrepreneur bug kind of earlier on, but went to college, decided, I really want to learn about the law and be able to, be a better kind of businessman, understand contracts, understand risk and exposure. So went to law school, never really with the intention of doing litigation and fighting, but more of just kind of educating myself, to get into business. And after graduating law school, my plan was, maybe be a corporate lawyer for a couple years and then go off and start my own business. And I kind of fell in love with the law. I loved helping different business owners grow and scale their businesses and help protect them against different risks that they may be exposed to. So I never actually ended up going the business route because I felt like I was better suited to help all those different business owners. So I joined my firm, Gibbs Giddon. I'm now the co-chair of our business law and real estate law departments, where I focus really on helping business owners of all sizes, from startups to middle market companies and entrepreneurs, scale their businesses, help them negotiate and draft contracts and essential business documents, whether it's raising funding, debt or equity, buying and selling businesses, negotiating contracts with suppliers or vendors, or really just their customers and clients, and make sure that they're not exposing their company to unnecessary risk, and making sure that it's going to be a long and fruitful relationship, because the linchpin of growing your business is those contracts with those suppliers or customers that allow you to grow and scale your business.
Wonderful. Well, this is great. I think of bookkeepers, our listener. They have a lot of face time with the owners, and it's not like we want to arm them with the legalities of things. But I think what would be really interesting is to talk about a few topics that give them a deeper understanding of it, and maybe a pathway to when they should be referring their business owners to a lawyer to do a deeper dive and do the important due diligence on certain pieces of their business. Because it's like anything, if you're coming into a business and you're going to advise a business owner, it's not that you want to be an expert in everything, but understanding all the different components as best you can just makes you a better advisor.
Absolutely.
So when we think of that relationship, you're probably familiar with bookkeepers and accountants' involvement inside of businesses. Do you see any situations where you go, oh, geez, that should have been handled earlier?
I do. And it's funny you mention it, because bookkeepers, it's a very unique and special business because you're so intertwined with that business owner. You're handling, their day-to-day finances and making sure that all their books are in order and they're really prepared. And then that business owner can spend time on actually growing the business. One of the areas that we do just see a lot of trouble is when things aren't negotiated or outlined earlier on. So you might have to start the relationship. Maybe you don't have a written contract. Maybe you haven't negotiated certain points. But one of the biggest items is really limitation of liability. And not to jump into kind of the meat of a contract, but that protects you as the business the business owner, and it protects the bookkeeper, because if something were to go wrong and you say there was a mistake that was made and that it affects the owner's business, the first person, unfortunately, that the business owner is going to look to is the bookkeeper and their business and say, well, you made this mistake. You need to bear the brunt of this, and you're liable for this. So it's really outlining that relationship and what liability does the bookkeeper and bookkeeper's business have to the business owner if a mistake was made, and outlining that earlier on in the relationship, so that if something were to go south, and hopefully that never happens, but if it were, the parties know who's responsible for what risk and the exposure that both parties have.
Very interesting. And so are there components of that contract that you often see overlooked? Like you're saying the liability piece is overlooked. I would imagine not even having the proper documentation or even having a lawyer review those things would be some of the challenges that people face.
Yeah, there really is. When negotiating the contract, there's I'd say maybe you kind of jump into like a top 10. There are things that really are overlooked, and it's so critical to have things in writing. And most businesses are great, and you have a contract, but I have seen many that it's a handshake. You started the relationship and you never put it down into writing, and that's where you get into trouble, because when that trouble does arise, and again, hopefully it never does, but when it does, it's always a he said, she said type argument. And when you have the written contract, that is how you're able to protect yourself. And not just yourself as the bookkeeper, but both sides, the business owner too, because both of you know what you've agreed to and it's documented. So I'd say, another one of the big items I see in these contract provisions is, an indemnity. And that may be overlooked. It's kind of a big, scary legal term, but what it really means is, if there's a third party lawsuit, does the business owner have an obligation to protect you as the bookkeeper? And that's when I see it's overlooked a lot. And if you're providing bookkeeping services, you really shouldn't be exposed to any other problems that business might arise that you don't have anything to do with. So an indemnity is a common provision that we like to add, saying that the business owner in the business is going to indemnify my bookkeeping business from any third-party claims, unless it's something that was caused by my actions or my gross negligence or willful misconduct. So if there's a slip and fall in the building where maybe I'm there, maybe I'm on the premises that day, that plaintiff isn't going to sue me because they sue, they're typically with lawsuits, at least in the United States, you're going to sue everyone and everything you can get your hands on, and they see, oh, there's this bookkeeper. Let me add them to this lawsuit. Okay, maybe far-fetched, maybe not. But if in a situation like that, you want to protect yourself and your business, because this is hopefully one of your clients, and you don't want to expose the rest of your business to something that you really didn't have a part to. You were just providing bookkeeping services.
No, I mean, I don't think it's actually far-fetched when you think about what can happen in any business. You're mitigating risk for yourself as a business and making sure that you've stated that this is not going to be some risk that you're going to take on. And so it's one of those, I think that's probably one of the pathways to not having things done properly is you think, well, it's not going to happen to me, or maybe this is too much, or I'm overthinking this. But it's a little bit of time on the upfront that could lead to serious mitigation of risk in the long term.
Absolutely right. And one other, as we're talking about it, another big one is just, how are you getting paid? Have you written that down? If the client pays you late, are you entitled to late fees and interest? Because even as a lawyer, unfortunately, I've got clients that, some things happen, especially in the current economic environment, and, we're not getting paid or invoices is late, but we have employees, we have our costs. So have you negotiated that? And are you entitled to late fees if the client doesn't pay you within, 30 or 60 days? Are you entitled to those, late fees and interest? And if the client doesn't dispute, your invoice or your contract, but they still haven't paid you, do they waive the right to make a dispute 6 months down the line? Because that's another big issue. A client may not raise a dispute, and that invoice is late 90 days, 120 days, and all of a sudden they say, well, this item I don't necessarily agree with, or this part of the contract I don't agree with. I'm not going to pay that portion of your invoice or honor the payment terms of this contract. So I'd really say, and it's such a big point, but it can be overlooked. Have you negotiated that? And have you really outlined the payment terms to make sure that you're fairly compensated for the work that you're performing?
It's interesting. I've heard that one actually come up several times inside of our community, where that's just exactly it. There's a bunch of work that's done, and then months down the road where something hasn't been paid, they're challenging what was done in the work. And so that's a huge exposure, and, a lot of time and energy that goes into these conversations that, with the proper documentation, the conversation is very simple and clean.
Yes. No, I couldn't have said it better.
That's a good one, and I don't think many think of that component. What else? If there are others that you see coming up?
The other one, I love my top 10 list. So, another one. Love
the top 10.
I love top 10s. I do it all the time. So please forgive me. But I thought about this, anticipation of coming on the show, and my 10. Another one that I have to mention is just the term and termination. If we're talking about contracts, what's the term and what's the termination procedure? Is it a year-long engagement? What if you can't stand the client? Can they, typically they're not going to be able to force you to keep working for them, but does that then have financial ramifications? Have you negotiated, this agreement, and can the client terminate you at any time? Is it a 30-day termination right? If that's what agreed to, that's not a problem. But really outline that so both parties are clear how you can get out of this agreement, and what are the rights to terminate in terms of, can I fire you at will? Do I have to give you a 30-day notice period? I hope that we've negotiated that you're going to pay me for all the work done to date. But really kind of hone in on that aspect too, so it's clear when each party can terminate the agreement, and if it's and for what reasons, and if it's terminated improperly, what are my remedies? As my bookkeeping business, I want to make sure that, if it's not a good relationship, doesn't work, okay, fine, no harm, no foul, but you need to compensate me for the work that I have done to date, and any type of reimbursement that I might have been owed in terms of, whether it was supplies, driving distance, whatever that might have been, that I'm compensated for what I've done up to that date of termination.
That's a good one.
Another one is, that I'm going to focus on, I kind of lump two of them together, and it's exclusivity and being an independent contractor. You want to make sure that, just push comes to shove, that you are able to service, if this is your business model, you are able to service different clients, and you're doing bookkeeping for many, to put it in the contract that you are working for other people. So, and I say this because I've had clients where they're performing a professional service for one business, and they're also performing the same business for a competitor of that business. And while I'm only performing, say, bookkeeping services, but use an example, I'm performing that for two wholesale plumbing companies, and one of them gets upset because I'm seeing all of their records and sales and financial data, and I'm doing it for someone else. And if things, again, churn in a direction that's going south in the relationship, we don't want them pointing a finger saying, you did something wrong, or you breached some type of fiduciary duty to me. Not that you necessarily have one as a bookkeeper in a contract, but you don't want some type of superfluous lawsuit saying, you took confidential information from me and you're working for a competitor. So really outlining that I'm an independent contractor, I'm not your employee, and I may be working for many different businesses, and one of them may be your competitor. I don't need to spell that out that it's a competitor, but just know that I am working for different types of businesses and other business owners. I'm not your employee. I am an independent contractor.
That's a good one, because I think that would come up probably quite often, especially when you're talking about maybe you have a specialty or a niche where you're focused on restaurants, let's say. You might have 20 restaurants in a small town that you're working with. They're competitors. And so in the agreement, you're stating that you work with others, but do you have a duty to let them know who they are? What are some of the challenges that might come up? I mean, even sharing industry standards could be viewed as sharing competitive information.
I would say you don't have a duty to disclose who your other clients are, and I wouldn't, because there are potentially confidentiality concerns.
Mm-hmm.
What you want to make sure you're not doing is that you're not taking any confidential information and using it with a competitor or sharing that information. So if I have the total sales figure for one company, I don't necessarily want to share that, even if asked, with a competitor, because that could be taking confidential information. What you want to make sure you're doing is, I'm working for client A. I'm keeping client A's information confidential. And it seems like it's common sense, but again, I've seen too many cases where common sense goes out the window, and it may be good intentions to help client B, but it's hurting client A at the same time. You may not have thought through that. So not necessarily a duty to disclose, but you do have that duty to make sure that you are keeping each client's information confidential to the maximum extent that you're able to do so.
Yeah, I would think so. And then what about the situation where you gain industry knowledge? You mentioned the top line sales or revenue of a particular competitor. Obviously, you keep that information confidential. What about the general overview? If you worked with 20 restaurants and you understood, this is the average revenue, I mean, that would be industry knowledge, right? The amount of margin, average margin, average cost of goods, things like that. How would something like that play out?
That's another great point. And that's knowledge that you've gained, and that's experience that you have under your belt to know that industry. It actually makes you as the bookkeeper more valuable, because you know that information. It doesn't belong to any one of your clients, especially Michael, in your example of I've worked for 20 restaurant business owners. I've gained that knowledge. I'm not taking knowledge from, again, client A and sharing it with just client B. I'm taking the knowledge that I've gained of the industry and I'm giving that to each of my clients. And that's something that you've earned, that is part of you in your bookkeeping business, that you would be entitled to share. And I think that would make you a better bookkeeper, and especially if you have that industry niche, because you'd be able to provide guidance while not breaching any type of duty of confidentiality that you might have to a certain client.
Yeah, absolutely. And that's one of the, for any listener that's involved in a niche or specializing in any area, this is what, pay attention, right? You're in this situation. Many people will be in a situation like that, not realize what the value is of what they know. But when you start to have benchmark understanding of what makes a business successful, that's valuable, way more valuable, especially if it's positioned that way. And then just making sure that you're understanding any legality issues that might come up, general information versus specific information.
Right.
Very cool. So that point is on, you are working, making sure that it's outlined, you work for other organizations, and that it's very clear to the business owner that they're working with.
You got it. So I'll jump into the kind of the last three on my list. And one of them is not necessarily a point that you always have to negotiate, because it protects you as well. And that's insurance. A lot of times in contracts, you as the independent contractor, bookkeeper, consultant will be required to meet certain thresholds. And that's an area that you do want to look at just to make sure that you actually have that insurance coverage, because I've seen that in contracts before where they may be requiring, not just professional liability insurance, but general liability as well. And my client didn't necessarily, they had insurance, but they didn't meet those thresholds. And when a claim was made on that policy, it exposed them because they breached the contract for not maintaining those levels of insurance. And I can't speak highly enough as to insurance, and make it suitable for your business. I mean, you don't need to go out and get a $20 million policy, but make sure the limits actually cover the risk, because that's what it's meant to do. It's meant to protect really both parties, so that my business, my bookkeeping business, is not going to be out of pocket because I can make a claim on my insurance policy, and it protects my client too. So, not saying that you don't want to negotiate the insurance and lower the limits, but just flag that and contact your insurance broker and make sure that you actually meet those thresholds. And maybe when you're talking to them, make sure that you're covered, especially with everything that's going on now. There's so many different new types of insurance policies with cyber terrorism. How are you keeping the books for the client? Is that on your computer? Are you keeping it in a cloud-based document? Can that get hacked? If it does, are you exposing your client? And making sure that you're covered for those situations.
Really interesting. And, it's probably a whole nother episode to get an insurance expert on to talk about that, because things are moving so quickly with the way the world works. And more, as more people move to the cloud, there's going to be challenges.
For sure. And I mean, that's a point that's really kind of industry agnostic as well. Even as a law firm, we're going through that. We have confidential client information and we're on the cloud now. So we looked into policies like that as well, and are looking to make sure that we're protected. It's because we're becoming a new era, especially with, we're talking now in the middle of the COVID-19 pandemic, with more and more people working at home and remotely. That type of kind of cyber terrorism and protection is just going to be even more critical. Even with the bookkeeping business, are you taking records home? Are they sending them electronically? Are you doing work on your home computer, making sure that you're protected from hacking? I know I've seen a lot lately with people hacking into even Zoom calls. And I feel like that's just an area that's going to keep growing. So it is something to look out for and make sure that you're protecting yourself as much as you possibly can. And insurance is one good way to do it.
And then that information would go into the contract that you're signing with and letting your client know.
Give your client know. And I think it's a good provision to add, even if it wasn't in there, giving your client some peace of mind. You're putting in that insurance provision. I'm maintaining these insurance thresholds, so your client is well aware of it, and they know that you're kind of looking out for their best interest as well. You have such a close relationship with them, and this is something it's a cost that either you're bearing or you might be working it into the cost that you're charging your client. But it gives them peace of mind as well. So it's something that I would include and make sure that they're aware of it, that you are insured.
Very good.
One other point to think about is, are there representations and warranties in your contract? Are you representing certain items, that you're delivering a certain work product, you're going to deliver, your services within a certain amount of time? Just be wary of those sections, because representations and warranties, it really benefits the client. And I wouldn't say that you never have to make them, but as the service provider and as the bookkeeper, I don't want to get hung up on, potentially breaching any representation that's made. So really, if they're in your contract or if you're using a client contract, take a second look at those and think through them and making sure that you're comfortable making those representations. And to the extent possible, if there's any worry, maybe put in a knowledge qualifier, which means, to my knowledge, I can make this representation. So that way, if I don't know that I'm breaching something, I'm not actually breaching it, because it's to my knowledge. And that's something that we as corporate lawyers like to do all the time. We fight all the time about whether we can qualify this to my knowledge or not. And whose knowledge is it to? Is it to my entire business and my employees? Or is it to myself as the owner of this business personally?
So that would be a clause that you would put in if you were signing somebody else's agreement. You'd say, well, I have to say if this was to my knowledge.
Yes. If I'm the bookkeeper, and it's my contract, I probably really limit any representations and warranties if I include them at all.
Yes.
But if there's negotiation back and forth and my client's attorney looks at it, or I'm using my client's contract and they put them in there, then I take that second look and I really think about to my knowledge and whether I'm actually able to make these representations at all.
Yeah, it makes sense. And this is an area that I think could be a very easy, slippery slope where best intentions, we're going to get back to you by this amount of time. We'll have these things updated by this amount of time. This is just setting yourself up for exposure.
You're right. And you led me into my final point. That was a terrific segue. And when you're delivering things, especially when there's a time, it's kind of a simple point. And it's access. Making sure your client is giving you access to the records that you need in a timely manner, especially if you've promised them a turnaround time, if you're getting close to tax season and they need documents, or there's a big investment coming up and they want financial statements, making sure that you have access to the correct people and the correct documents. Because if a client's delaying giving you access for documents, that affects your turnaround time. And what we don't want to happen, and I've seen it all, so I've seen this too, is I'm late with my deliverable, but it was because of the client. They didn't give me proper access, but they're still upset. They're still pointing the finger at me saying, the ramifications of your late delivery has cost me money. I want to eliminate that situation. And I do that by putting a simple provision in my contract saying, you're going to give me prompt access to documents. Any request I make, you're going to give it to me within, a business day, 2 business days, 3 business days, whatever that number is. But we're clear on the client's responsibilities and my responsibilities as the bookkeeper.
That is a great one. And I think that's probably a very simple, like you say, a very simple wording, which just is, if I promise you I'll get back to you by X amount of time, and I say, granted, I have these pieces from you, that's a simple transaction. Whereas without that, I'm fully exposed.
And that's why I saved it for last. It's a lot of these points, they're simple, and you don't even really, it's not advice that's coming from an attorney. It's, you think, I don't need access. Of course they have to give me the documents, otherwise I can't do my job. But they may give it to you late, and it's that second detail that has the ramification. They may give me access, but it's late, and now my deliverable is late, and maybe my client had a big investment coming in, and they needed their books in order, and they just engaged me to get everything up to speed, and they were late giving me documents, so I was late, and now the investor walked. Well, now my lawyer hat goes on and says, well, that could be an issue. Is the client now going to make a claim against me because they lost this investor? Well, now we go back to one of our first points, to our limitation of liability. And that's why that point is very important as well. They're all kind of, that's why I have the top 10, because, one of the points by itself may not seem as important, but when you think through the ramifications of it, it may trigger another one, like the limitation of liability or the insurance.
Very cool. Now, this has been fantastic. Some great points to be thinking about, including in the contract, and really just an understanding of why they're there and the impacts and the reasons why you'd want them. Now, feedback I get, and it's not just in this industry, but any industry, is the length of contracts. Pushback from saying, "Wow, there's a lot of fine print here. This is too long." And I've even heard of people saying, "Oh, I just cut all that stuff out and made it very simple, one pager." There's this balance between being efficient and straight to the point, and then also making sure that what needs to be there is there. What are your thoughts on that?
It's a great point, and it's something that we struggle with really on a daily basis, because frankly, it's really hard to do a short agreement, because, I often joke, do you want it short or do you want it good? And it's not really a fair analogy, but I say it joking with clients, because, they say, I want a 1-page agreement, not just with a contract with this, but really across the spectrum. People want things short, attention spans are short, but it's a trade-off because the shorter we get, we're not able to get some of that detail. So what I would say is it's really a risk analysis. Do I need, the section on insurance or late fees? It'd be great to have, but maybe I can jettison those because, I don't need the late fees. Do I have to get into the termination? Yes, I should, but can I get rid of that? It's really an analysis of the contract provisions and what you can do without to make the client and yourself happy. It'd be perfect if you could have the long form agreement, but sometimes it's just not feasible, or you scare the party away, or you lose business. So you have to make that analysis. And if it comes to that, maybe you're able to supplement that in some way. Maybe I'm not going to have quite as detailed a limitation of liability, and it's not going to be 4 or 5 sentences, but it's one line, and I'm able to get the point across. And I decide, okay, I'm going to get my business an excess liability policy of insurance because I'm a little bit more worried about this contract. It really is a trade-off. And there isn't a perfect answer because it really is on a case-by-case basis. One client, you may have a little more hesitation. So maybe that client, you said, I need to have these provisions. But my long-standing client, I've dealt with this person, or it's a friend, and I know them better. Well, I still always encourage you to, try to at least hit the top provisions. Maybe in that situation, you can jettison something that you wouldn't for a different client.
Yeah, I think so. And I think it's positioning too of any document. And so making sure that people, if you hand them a 10-page document, well, what is all of that? What does it mean? Why is it this way? If you position it that it's there to serve both, that's a different context going into it. Now, I do have a question around this in terms of, we sign up for things like if you get a Google account, we're entering into an agreement with Google when we sign up for, say, a Gmail account. And often it'll just be, all I got to do is put my email in, but I'm signing off on the terms of use. How does that situation work in terms of if in a classic situation, you're going to engage with somebody, you're going to sit down, you're going to go through this agreement, they're going to see this 10-page agreement, they sign on at the bottom of this. But then online, often that 10-page agreement is kind of hidden, if you will. You have to actually go and take a look at it. Do you think that we'll be moving more towards that in general business, or is there a challenge with doing something like that?
It is a challenge, and it's not just like a Google contract. I mean, you have these, we kind of call them contracts of adhesion that you're signing on to, and you really can't negotiate them, because if you do, that provider's just going to say, you can't use my service. And you see that with like a Google agreement, maybe your cell phone contract, you're going on a cruise or a trip, and you're agreeing to their terms. You're going skiing, and by buying that lift ticket, you don't even see the contract, but you're agreeing to their terms and conditions, which a lot of times is excluding them from any type of liability whatsoever. And certain industries kind of get away with it, but unfortunately, with especially on the smaller side, when we're dealing with business to business type contracts, if someone actually reads it and negotiates it, you're not really able to say kind of to take it or leave it. Which you could do. You could say, this is my contract, you sign it as it is, or I'm not going to do business with you. But usually as, small and medium-sized business owners, we want the business and we don't want them to turn it down. Google, or let's talk about, I took my kids to Mammoth earlier that year and bought the lift tickets. Even as an attorney, I didn't know all the terms and conditions, but I accepted it because I knew if I didn't, we're not going to get to go skiing, and my 4-year-old's going to yell at me. So we went skiing. But if I'm doing a contract, with a client and they're negotiating it, what I might say is, these are here to benefit us both. We are going to have to negotiate it because I want their business, and I tell them, this is my form contract I use with all of my clients, and send it to them. But if they review it, or if their attorney reviews it and they want to negotiate some provisions, I will negotiate that. But we'll try to meet, really in the middle and hammer home the point that this is to protect us both. It's not just to protect me as the bookkeeper. It's to protect you and make sure that you have a right to terminate the agreement, and that I have insurance, and that if there are reps and warranties, that we know what they are. So it's really a two-sided agreement, and that's usually very successful in getting people to sign it and actually take a minute and read through those 10-page agreements.
Fantastic. Very helpful. Jeffrey, this has been absolutely fantastic, very valuable. Where can our listener learn more about you?
One of the best places, I'm very active on LinkedIn. I post a lot of content there. I hope that this podcast will, as soon as it comes out, I'd love to post it to my audience. So go there, you get helpful content. Also, check out our firm's website. It talks about, my background. It's www.gibbsgiddon.com. And we post a lot, not just for myself, but other partners, where I think it's a lot of helpful information regarding, we have a couple of attorneys that deal with insurance. I deal with corporate law, and there's some helpful tidbits of advice and articles that your listeners may find interesting.
That's beautiful. Well, we'll have all of those links in our show notes. And Jeffrey, I want to thank you on behalf of all of our listeners for coming and generously sharing your knowledge and experience with us today.
I'm happy to be here and had a blast talking.
Beautiful. And with that, we wrap another episode of the Successful Bookkeeper podcast. To learn more about today's wonderful guest and to get access to all sorts of valuable free business building resources, you can go to thesuccessfulbookkeeper.com. Until next time, goodbye.
You've been listening to The Successful Bookkeeper with Michael Palmer. For more information and to download the resources mentioned in this episode, please visit us at thesuccessfulbookkeeper.com. Thank you for listening.